And welcome to Facts or Frauds.
Mr. Valentine, it is? We need to get you unmuted.
Yes, ma'am.
All right. So there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay. I just need to always make sure of that. All right. So you filed some documents with the court and we've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court, and I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's the state's understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.
That's not part of the motions I have here that were filed.
There was a motion filed. I can look it up real quick, Your Honor.
Since the last hearing is what I was looking at. So there was...
Yeah, I objected to his denial of those motions as well because I already submitted an affidavit of prejudice and he disqualified himself. So he shouldn't have been making any judgments on the case after that point. He also said himself that today was going to be a special motion docket where my motions were going to be heard today.
So what I reviewed is what was filed after the 18th, and that was October 21st. I have a request to release you and your request, let me get back to your court to dismiss these charges, motion to release you, and that's what I reviewed. So is there something else pending that I was not aware of after the 18th?
On this October 18th, there's one that says in Laserfish motion to request discovery, parentheses 020, parentheses. In that one, that's based on the state's notes. It shows that that was the only motion that was going to be argued today.
All right, Mr. Valentine, it looks like I need to go back and kind of review real quick those issues. I thought they were all heard on the 18th. And either you can just sit right there while I read everything here, or which probably is the best thing to do. So let me just review all that you've filed here again. And then I'll turn right back to you. So just hang in there. So just before I get to everything, Mr. Valentine, I'm looking at your motion request. I guess you titled it to request all of the discovery in this case, but you say that it seems to me, maybe I'm misreading one, that Michael Valentine had an attorney in the early stages of the hearings. Is that just a fact, or are you asking the court to appoint counsel?
I'm stating a fact that at the beginning of these proceedings, I was working with an attorney. The first
And then
attorney
they
I was
never
working
gave
with,
you the discovery.
yes.
Okay. All right.
Yes.
All right.
Multiple.
All right. Get it.
That's the
Thanks.
state's understanding as well, Your Honor.
Okay.
And our office did provide discovery.
Well, just slow down. Let me read everything and then I'm going to turn to everyone. Just needed some clarification there. All right. I've had some time here to re-review and review what's been filed in the court file from the 18th of October on forward. As to your motions from the 18th on forward and the docket and your pleadings. So as to discovery, let me direct first to Mr. Weston on behalf of the state. Has all discovery been provided to Mr. Valentine?
Correct, Your Honor. So on October 18th, 2024, Judge Buckley ordered that the state provide Mr. Valentine discovery. 5 days later, DPA Thompson himself drove to the jail and delivered all discovery material to Mr. Valentine, which included the citation, police reports, an offer sheet from our office, thumb drives of dash cams, and then the request forms for those dash cams as well.
Okay, so a thumb drive that he could view those, a request form for the dash cams. What does that mean?
That when there's a dash cam involved, such as here, our office generally has to send out a request for that dash cam, and that form is just a request asking Washington State Patrol to disclose their dash cams to us.
Okay, but you provided a thumb drive that had those dash cams.
Correct, Your Honor. Thumb drive of the dash cams.
And all this information is what the state intends to use in trial against Mr. Valentine.
Correct, Your Honor. Based on the subpoenas that I looked at recently that were sent out for trial, the trooper that's testifying is one of the troopers that is testifying. His dash cam would be on this drive. The police report of that trooper would have been provided in this discovery packet as well. All the information that we would be using at trial was in this discovery packet that was provided to Mr. Valentine on December 23rd.
Was it provided before this at any point?
The state is unaware on whether it was or not. The state had the belief that defense counsel, who was previously representing Mr. Valentine up to a certain point, would disclose such materials to him when the court found that when the court allowed Mr. Valentine to proceed pro se. But this state doesn't know why it wasn't provided to him from the prior defense counsel. But upon realizing that Mr. Valentine did not have the discovery packet, the state did provide such material at that time.
And on the witnesses that you're expecting to call to testify, the substance of their information is included in that discovery?
I would believe so, Your Honor. Based on the, give me 1 second here. And so based on the subpoena that was sent out, one of the witnesses are Trooper Benjamin Crabtree, one of a dragger technician, and because there was one of the charges is driving while license suspended, there is a DOL representative that it will be a witness in the trial as well. But everything that Mr. Valentine would need to cross-examine Trooper Crabtree would be provided either on that dash cam or in the police report. Additionally, Mr. Valentine would have ample opportunity to develop his cross-examination of the dragger technician or the DOL rep at trial.
It looks like a witness list was provided while Mr. Gasling was Mr. Valentine's attorney back in the beginning of the year, at least March, I believe it was. And that included Trooper Crabtree, Zach Riveri or Assany, and Skylar Rue or designee from the State Department of Licensing. All right. You've reiterated that witness list, it looks like.
Correct, Your Honor.
All right. What's that? All right. So, and then, all right. So then, Mr. Valentine, as to that discovery, You thinking you're missing something, or you should have something else in discovery?
No, ma'am, I didn't receive the discovery in a timely manner. Counsel was ineffective with sharing the discovery footage or the reports with me. I asked on multiple occasions to obtain the video so that I could build a proper defense. And they told me on multiple occasions that it had to be approved by the prosecutor and redacted, which never happened. I waited and waited, never happened. And after counsel's ineffectiveness, this is where I made the choice to proceed Sui Juris because I had my own best interest in mind. And it seems that the public defenders that were appointed to me were not assisting me effectively. And this was recreating a manifest injustice. So now I have received it a few days before we're supposed to be going to trial. I have reviewed the footage, and there is fraudulent and misleading statements made by the trooper that I have already submitted a motion to suppress that evidence that I'm sure the court will be getting shortly.
Okay. And so all right, so we're a couple weeks before trial, or before confirmation. We've got trial scheduled the 18th, so we're 3 weeks out. All right.
Yeah, I would ask the court that either the prosecutor or counsel be sanctioned or some remedy be met for the violation of the discovery rules.
Well, I'm not finding there's a basis in your pleadings or what I've heard today to sanction anyone for a violation of discovery. So I'm not going to do that. And now you're also, I mean, I don't know if this was dealt with, but throughout your pleadings, you're concerned about this court, district court having jurisdiction over you. Is that still at issue, sir?
Yes, there was some service issues, as I mentioned before, which for some reason keeps getting ignored. The state served my address knowing well that I was in custody. They didn't serve me the court docket for the last hearing. And that lack of service creates a lack of jurisdiction for the court.
I disagree. Those are different issues. Go ahead, though. Maybe you've got something else there. What?
Oh, I was just going to say there's also been a number of courtroom violations taking place, which is why the last judge ended up recusing himself. But beyond counsel being ineffective in mounting any defense, they convinced me to give up constitutional rights instead of enforcing any constitutional rights. They lacked to challenge anything that the state was doing. They didn't challenge or attempt to suppress the evidence. They didn't even share the discovery information with me upon my request. And the court also was violating General Rule 43, my personal pronouns, continuing to try to say I'm pro se instead of Sui Juris, not changing, acknowledging my name or acknowledging my status as an American national. I also submitted a letter from the Washington State Attorney General's office where they're acknowledging my status as an American national. They're acknowledging my fee schedule, but for some reason this court hasn't been acknowledging my pronouns at all.
Help me understand what you would prefer.
I would prefer to be identified as Sui Juris, not pro se. I prefer to be identified as Michael Valentine, grammatically correct, not in all capitalizations. I am not a legal entity. I am not a corporation. I am not a trust. I am a living man, not a male. Living man. And that's how I want to be identified, ma'am.
So if I say Mr. Valentine, that's not what you want.
I would like to be preferred as American National Valentine.
Okay. All right, I can do that.
Thank you.
Sure. All right, so the jurisdiction, whether Thurston County District Court has jurisdiction over you at this stage, what it is an allegation of criminal behavior alleged to have been occurred here in Thurston County, State Route 510 here in Thurston County. And so that, and it's driving under the influence. It's a gross misdemeanor. So the district court does have jurisdiction over those things and over you, whether you agree with the court or not. I find that today. And then discovery sounds like it's been provided. We're 3 weeks out from trial.
We're 3 weeks out. The trial was like next week.
Well, next week, the 8th, is the day. It's called confirmation. It's when everyone determines if they're ready for trial or if we should have trial on the 18th and 19th. So the 18th and 19th is trial. So we're 3 weeks out. So I'm finding that thus far that discovery has been provided by the state to you.
But it wasn't in a timely manner. It wasn't by the omnibus hearing, which is the prosecutor's obligation.
Well, and it was provided to previous counsel who was with Thurston County Public Defense. I don't have, there isn't any counsel here today now because fairly you've decided to go sui generis, as you say. So
and that's why my motion for discovery asked for an investigator, because someone needs to investigate all these rules being broken by counsel, prosecutors, and various government individuals.
All right. Well, I'm not finding those rules being broken. It's kind of a broad and encompassing idea. I'm trying to narrow this in. See, discovery has been had.
To share the discovery with me and to contact me and to help build the case. If I'm requesting a discovery, wouldn't either the prosecutor or counsel have an obligation to provide that discovery?
And I see that they have now, the prosecutor has. Now as to...
But they didn't previously is my point.
Right, and they have now. And I don't find at this stage a reason to sanction anybody or to term anybody for that. There's 3 weeks out to trial. It's sufficient time. So, I also have a motion for release. That was also, let's see, and a motion to dismiss.
And the motion to release and dismiss were both heard on the 18th. And I can provide some underlying facts.
Mr. Valentine, there's something on the 18th, but then you refiled information that I reviewed on the 21st, also asking the court to consider release and a motion to dismiss the action against you. And is there something different than what you argued on the 18th that you filed on the 21st?
I didn't get to argue anything on the 18th. The judge read and made his own decision. I didn't argue anything. He told me on the record that I would get a chance today to argue my motions. And he made this decision after he disqualified himself per my affidavit of prejudice for him breaking rules of judicial conduct, the code of judicial conduct, obstructing my right to be heard, where I believe it was 9/20, 2024 at a pretrial hearing. He did not allow me to speak. I had judicial notices and motions I found in a timely manner, and I presented certified mail receipts of the time that those were filed to the court as an exhibit, and he didn't allow me to speak or acknowledge any of those notices or motions, which is denying me access to court and obstructing my right to be heard, which is a constitutional right, a violation of due process.
All right. And I think I understand that what you said there in your pleadings here. Now I understand that maybe that didn't come back before the court then. So here we are. So first things first, let me get back to, I have a few things up here electronically. That's why I'm looking back and forth to screen. So there it is. And so the basis for the motion to dismiss is
deprivation of my constitutional rights under the color of law, governmental misconduct, and effective counsel.
And then and then that kind of follows thereafter. If the court were to grant that, then a release from custody, or is there something else on your motion for release?
No release of the, is there something else besides the, could you rephrase that? I'm not sure what you're asking.
Sure. Well, it makes sense that if the court were to grant your motion, to dismiss, then you would have to be released. Is that what you mean? Or is there something in addition? If the court weren't to grant the dismissal.
If they didn't dismiss me, I wanted to adjust the release conditions so that I would have a better chance at defending myself if I were released from custody. I feel like the state took extreme measures in making sure I show up to court, and I would ask, if dismissal is not granted, that we adjust that to some less restrictive measures so that I can go home, have access to the internet, to paper, to private phone calls. I would be betterly suited to defend myself if I weren't confined.
I got it. Okay. All right. Well, let me turn to the state on the issues of the request for dismissal and well, one thing at a time. There are two different motions, and then the release conditions.
Your Honor, the state would strongly object to the court dismissing this matter. We're nearly 3 weeks away from trial. There's ample evidence to support that, to move forward with this. Additionally, an ineffective assistance of counsel claim is a matter for appeal. And so for Mr. Valentine to provide to even file that, we would have to wait for the criminal trial to come to an end. Additionally, on the hearing on October 18th, Judge Buckley provided Mr. Valentine with resources. I remember watching the Zoom recording, and that Judge Buckley informed Mr. Valentine that he would be provided with legal resources that would help aid him in mounting a defense against the state. So the state would wholeheartedly object to the motion to dismiss. Regarding the conditions of release, we also talked about Mr. Valentine brought this motion, the same motion, on the 18th, where the court denied that motion as well. Part of the facts underlying that is, during that time, the state did move to dismiss one of the DUIs at that time. And so based on that, the court still found that there was a real concern for public safety. And so the court still kept the bail imposed. Additionally, from the 18th to today, according to CRR-LJ 3.2, the court can only modify conditions if there's a change of circumstances, new information, or a showing of good cause. And there's been nothing within the last 10 days that has shown that has been provided or mentioned that would fall under one of those, except one of those reasons. Additionally, I've received information earlier today that the state has received talks report from the DUI that we dismissed a week on the 18th.
Well, let's stay on this case alone.
And so the state would have some real concerns on whether
let's stick to this case and not bring in any other facts from any other case.
So based on that, there's been no change in circumstances, new information, or showing since the last hearing we had on October 18th. The state would object to reconsidering conditions of release. Additionally, the motion, no, never mind, Your Honor. We would just object to the motions being reconsideration of the motions, reconsideration of the conditions of release.
Mr. Valentine, anything else?
Yes, ma'am. I would like to say, first of all, that the prosecutor shouldn't have held me or pressed those charges in the first place if they didn't have sufficient evidence for a conviction that created a prejudice status in my case. There's been many other individuals who were booked who... Are
you also talking about a case that's not this case, or is it this matter you're talking about?
I'm referring to how the prosecutor had other charges pending, which was a condition
I'm
of
not
what
going to consider any other charges, either side. Let's focus in
okay.
on this one and this one alone.
Okay, so for these charges, I would be challenging the evidence that the state has. I don't believe they have probable cause. The trooper is claiming that I almost struck him. I did not almost strike him. And it's clear that there's discrepancies between his report and the video footage that I observed. I am not a danger or threat to public safety. I caused no harm. I cooperated with police. I pulled over when I was asked. I've been operating in good faith and have come to court and tried to resolve this to my best effort. I did a DUI impact panel. I was on an ankle monitor, and I've been in here for multiple months now. I think I've shown that I am operating in good faith, that I am trying to get this resolved as soon as possible, and I would ask that you consider that.
Just looking through your pleadings and docket and all the information in front of me in the court file.
And if I may add, Your Honor, I was never cited for any traffic violation. The state trooper made an assumption claiming I almost hit him. His back is to the camera as I'm passing the vehicle. I did my due diligence and gave him room because they're standing right on the shoulder line of the side of the road. I moved over and gave them plenty of room and went around them, and that's clear in the video that I was never close to striking his vehicle or the pedestrians on the side of the road.
Okay. Well, it's good that you've been able to review that information. So, all right, let's see if I have any other questions of either of you. Hang on a second. Let me just kind of review things. All right, so a couple of things to take up here. So disputes as to evidence, I mean, that's why we have trial scheduled. You'll have an opportunity to cross-examine all witnesses that are brought by the state. And of course, any witnesses will be available to both sides. The state shall not excuse anybody from their witness list until the court allows it, so that American National Valentine has the opportunity to question them. So who's on your witness list stays on your witness list. I found that discovery has been provided. I'm not finding it's untimely, given the 3 weeks we have till trial. As to release conditions, the unfortunate part is I'm not going to change those conditions of release. They've been reduced to $5,000 cash or bond, and that you stay clean and sober and law abiding. And but given the amount of time we've had to issue warrants to get you back before the court, that's really a big part of why you have to postpone to get back in, and also because DUIs do pose a danger to the community. So, and denying your motion to dismiss, there's nothing before the court here. I think you're going to have this opportunity to question and present evidence at trial, and that's what that's for. That's not a basis. The disagreement in evidence is not a basis to dismiss at this juncture, and you will not be released on different conditions. The conditions stay the same.
Yeah, my motion to dismiss was based on the misconduct. It wasn't based on the evidence.
Well, I read several motions here, so thank you. I saw it also as to what you've said today about evidence or the lacking thereof. Misconduct, I haven't found any. I don't have enough evidence here to show that anyone was acting wrongly. If there is an ineffective assistance of counsel from before you chose to go representing yourself, then you would have to show how it applies if you're convicted, how it applied to that conviction, and if there was in fact ineffective assistance of counsel, but you're representing yourself. So that's, and it doesn't make a whole lot of sense right now.
I'm not doing that because counsel was ineffective. and the last judge denied me access to court and obstructed my constitutional right to speak. Isn't that grounds of misconduct, ma'am?
I don't find, I don't have enough evidence to find that. So
there's
that's the issue.
I have witness statements that were submitted to the court. My family showed up at court and witnessed the judge not let me speak, not let me present my judicial notices or motions. And it's also recorded that he did such.
So I know you disagree with the court's decision.
To the fact there's misconduct?
I don't find misconduct. I don't have enough evidence to find that. And so we're set for trial confirmation November 8th. I'm going to keep everything set as is. Trial is scheduled for November 18 and 19. And if you postpone, then you bring yourself in. If you don't, then we'll be sure that you're there. The facility will be sure that you're there.
I'm indigent, ma'am. I cannot afford a $5,000 bail. Is there any way we can bring that down anymore?
And again, I'm not going to change that bail amount. We've reduced it already earlier, and I don't see a substantial change in circumstance is what Rule 3.2 requires of me. So everything stays the same. All right. So covered everything. Yep.
To a higher court.
You can always go to the Superior Court and ask for a writ to overturn any of the district court's decisions. But right now we're still proceeding to trial until which time the higher court tells this court to stop or to do something else.
Yes, I am.
So that's it for this afternoon. I'm just going to send you down notice again of all the court dates so you have them. And then we're back November 8th is our next court date. And you have that in hand. All right. I think that's it for the afternoon. Thanks, Mr. Thanks.
I had one more question.
Yep.
So I still have to have a scram bracelet and can be released on my first DUI. Isn't that for people who have previous convictions of DUIs?
It can be. It can also be because of a history of use and a nexus to that.
Where is that history of use?
Well, we've got things, let's see, going through a history of crimes committed either under the influence or minor in possession or controlled substance possession alleged in Olympia. Well, that allegation was going on, and then this allegation. So all of that.
How long ago was that?
And then as a juvenile, there were several events as well. So there's a nexus to the criminal history that the court knows of, as well as the event itself. So the conditions remain the same. And we'll be back November 8th. That's all for today.
You can't fix stupid.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so next time I premiere a video you can be in a live chat with everyone else and leave a comment in the comment section. Tell me what you think.
And a huge thank you to all of our Facts or Frauds channel members.
And if you're still hanging out, thank you. I appreciate you all. Make sure you hit that thumbs up button, you're subscribed, and leave a comment in the comment section. Tell me what you think. Until next time, I'll see you soon.